Hello everyone. As you know, immigration news changes almost daily, and these updates can impact your case, your family, or even your long-term future in the United States. Since our last update video, there have been a number of important developments across multiple areas of immigration law that you should be aware of. My name is Remzi Kulen, and I've been practicing immigration law for more than 20 years. I understand how complex and overwhelming these changes can be, and I'm here to help you navigate them clearly and confidently. Today, I'll break down all the latest updates, including Visa Bulletin movement, H-1B changes, diversity visa developments, new fees, and ongoing visa processing delays. Let's start with the Visa Bulletin. The April Visa Bulletin brought very significant forward movement, levels not seen since the COVID period. USCIS confirmed that for April, the dates for filing chart would be used for both family cases and employment-based cases. In the family-based categories, F2A became current for filing, while final action dates remained unchanged. F2B advanced in both filing and final action dates. In the employment-based categories, we saw major progress. EB2 became current for final action, advancing from October 15, 2024. EB3 moved forward significantly from October 1, 2023 to June 1, 2024. Under the dates for filing chart, EB3 was current. Previously, it was January 15, 2024, allowing many applicants to file adjustment applications. Overall, this represented approximately 1 to 1.5 years of forward movement, a substantial development, particularly for perm-based applicants. One possible explanation for this advancement is reduced demand for immigrant visas. The State Department has paused immigrant visa processing for nationals of certain countries, which may temporarily lower demand. When demand decreases, visa numbers can become available more quickly, resulting in forward movement. However, the May 2026 Visa Bulletin introduces an important shift. USCIS has announced that it will now use final action dates as opposed to dates for filing chart for employment-based categories. This change is significant. While the underlying dates have not moved backward in the chart itself, the switch in which chart is being used effectively limits eligibility. Let's look at the categories together. EB2 final action date remains current, so there is no change. In the EB3 category, final action date remains June 1, 2024, so there is no movement. However, last month, under the dates for filing chart, EB3 was current, which allowed many applicants to proceed in the month of April. But if your numbers are not available in the final action date in the month of May, you will not be able to file your adjustment of status application. How about other workers? Final action date is February 1, 2021. This category was also current last month under the dates for filing chart, allowing applicants to proceed at that time. Although EB3 did not retrogress in the final action chart itself, the shift from using dates for filing to final action dates effectively results in retrogression for many applicants. Additionally, EB3 dates for filing remain at August 1, 2022, but this chart is no longer being used. This means EB3 is no longer current for filing in the month of May, and eligibility is now strictly limited by the final action date in the month of May. Applicants must have a priority date earlier than June 1, 2024 to proceed. Those who were previously eligible under the dates for filing chart may no longer be able to move forward at this time. So while April brought significant forward movement, May reflects a tightening of availability due to the shift in the chart usage. This underscores the importance of acting promptly when visa numbers become available, as forward movement can be temporary and subject to reversal. Let's talk about immigrant visa pause for 75 countries. As I mentioned earlier in the Visa Bulletin discussion, the State Department has paused immigrant visa processing for nationals of 75 countries. This includes countries such as Azerbaijan, India, Brazil, Pakistan, Egypt, Nigeria, and Bangladesh, among many others. It is important to understand that this visa pause applies only to immigrant visas. For example, let's say you are a US citizen and you file an I-130 petition for your mother and she is from one of the affected countries, for example, Azerbaijan or Pakistan. You can still submit the application and the case can continue moving forward through the process. However, at the final stage, the visa will not be issued while this pause is in effect. Applicants can still submit applications, attend interviews, but no immigrant visas will be issued during this period. How about non-immigrant visas, such as tourists, students, or work visas? These are not affected. The practical impact is significant. We expect delays now in the immigrant visa processing and potentially large backlogs once processing resumes. Let's talk a little bit about the H-1B specialty occupation or professional worker visa. There have been several important developments in the H-1B program recently. First, the H-1B cap lottery for fiscal year 2027 has now been completed. USCIS released the selection results at the end of March, and only selected applicants are currently eligible to move forward with petition filing. While official numbers for this year have not yet been published, prior data provides useful insight into recent trends. For fiscal year 2026, USCIS reported an overall selection rate of approximately 35%. Based on our office's experience, the selection rate among our clients for 2026 was approximately around the same number. At this time, there is no official data available for fiscal year 2027. However, based on our experience, the selection rate is around 53% in the office. Let's not forget, there remains a possibility of an additional selection round later in the summer, potentially around July, August, although this is not guaranteed. Now, beyond the lottery, there have also been major policy changes affecting future H-1B seasons. DHS has introduced a weighted selection system in this year's lottery, which replaced the traditional random lottery. Under this system, cases were ranked based on the wage level, higher salaries received a greater chance of selection, and lower wage positions have become significantly less competitive. In addition, there is a new $100,000 fee in the H-1B program. This fee applies only to new H-1B petitions filed through U.S. consulates abroad. It does not apply to change of status cases inside the U.S., and it is not paid at the registration stage. Separately, the Department of Labor has announced a new prevailing wage rule, which is expected to change how prevailing wages are calculated. This may result in higher required wage levels for many positions and could further impact H-1B eligibility and strategy going forward. Although this year's lottery process is now complete, the H-1B system itself is undergoing significant structural changes. We may still see additional policy updates, litigation, or even revisions to these rules. So while the lottery is conducted, the H-1B landscape is still continuing to evolve, and we will provide more updates as they become available. Let's talk about the asylum cases, because there is now partial resumption of processing of asylum cases. The government has now begun resuming certain asylum cases following a prior nationwide pause. To give some context, asylum adjudications were broadly paused in November 2025 following a security-related incident. That pause lasted for several months and effectively halted decisions on many pending asylum cases. Then, in early April 2026, the government began partially resuming asylum processing. Under this updated policy, USCIS is now moving forward with cases for applicants from countries that are not subject to travel restrictions. However, cases from certain countries may still remain on hold due to additional security screening. This means that thousands of pending asylum cases that have been waiting for months may now begin to move forward. At the same time, processing will not be consistent. We expect continued backlogs, case-by-case delays, and differences depending on nationality. For applicants, uncertainty still remains, especially for those from restricted countries. There may be additional document requests, extended security checks, and longer processing timelines. Processing is expected to return to normal gradually, not immediately. So, while this is a positive development, it is not a full return to normal operations. Applicants should continue monitoring their case status closely and be prepared for possible delays. Let's talk a little bit about the DV lottery. As you know, this year, the diversity visa lottery has not yet opened, and we are still waiting for an official announcement. There is no immediate cause for concern, as some people think. Even if the program opens later than usual, including a potential opening in August, let's say, applicants would still be able to submit their entries in time for the October filing period. At this stage, we continue to monitor developments closely and will provide updates as soon as more information becomes available. At the same time, there are serious developments affecting current DV applicants. As of December 2025, the State Department has paused all diversity visa issuances worldwide. This means that interviews are still being scheduled and conducted. However, no visas are being issued at this time. In addition, all DV cases are now subject to mandatory interviews, increased scrutiny and review, and the key concern here is absolutely timing. DV cases are strictly tied to the fiscal year, which means they must be completed within a limited time frame, which is by September 30th of that year. As a result, these delays create a serious risk. Some applicants may not be able to finalize their cases before the deadline. Now, looking ahead, there are also important rule changes coming to the DV program. The Department of State published new rules on March 11, 2026, and implementation is expected in the month of April. If you are planning to apply for the next lottery, DV 2027, here are the key changes. First, a valid passport will now be required at the time of the registration from the principal applicant. Second, applicants must enter passport details and upload a copy of the passport biographic page. Third, the DV lottery will now include a $1 registration fee to prevent fraud. This is a significant change from the previously free system. And fourth, the application form will now use the term sex instead of gender. These changes are designed to increase verification and reduce fraud. But they also mean that applicants must be much more careful when preparing their entries. At this time, the Department of State has not yet announced when DV 2027 registration will open. We are monitoring closely and will share updates as soon as official dates are released. Let's talk about the new $1,000 parole fee. USCIS has introduced a new $1,000 fee that applies specifically to certain parole-based requests. This fee is generally required for individuals applying for discretionary parole into the United States, including certain humanitarian parole programs or case-specific parole requests filed with USCIS. It does not apply to standard immigration processes, including marriage-based green card applications, employment-based petitions, and green card cases. Change of status or extension applications. Because parole is a discretionary and case-specific benefit, this new fee primarily impacts individuals seeking entry or temporary stay in the U.S. based on urgent humanitarian reasons or significant public benefit. If your case involves a parole request, it is important to evaluate eligibility and strategy carefully before filing, as both the cost and adjudication standards may be significant. Expanded visa screening and vetting is something we should definitely mention. This is an important update affecting a wide range of visa applicants. As of March 30, 2026, the Department of State has expanded its screening and vetting procedures for visa applicants. Under this change, consular offices are now conducting broader reviews of applicants' social media and online presence. This enhanced screening applies to multiple non-immigrant visa categories, including H visas, F and M student visas, J exchange visas, as well as K, R, T, U, and others. In many cases, applicants are now being instructed to set their social media accounts to public so they can be reviewed as part of the application process. The key point here is that every visa decision is being treated as a national security determination. This means officers may rely on any available information, including online activity, to assess eligibility. As a result, applicants should expect more detailed review, possible delays, and increased scrutiny during the process. It is now more important than ever to ensure that your application is accurate and consistent, your supporting documents align with your case, and your online presence does not create any concerns. This is a significant shift in how visa applications are evaluated, and applicants should be prepared. Because there are a lot of updates, I decided to do this in two separate videos, so the other developments will be in my second video. Please don't forget to watch that as well. If you found this video helpful, please like the video and also subscribe to the channel. I will see you in the next video.